We'll get started. Good afternoon, everyone. Hi. We're going to get started just so we can maximize our time. My name's Jocelyn Kennedy. I'm the Executive Director of the Harvard Law School Library, and I want to thank you all for being here. Copies of today's book, Is International Law International, are on sale outside the room, and I think Professor Roberts would be happy to sign them after the talk if you're interested. Today's talk is being recorded by the law school. It'll be on the law school YouTube channel early next week. The question and answer period is also recorded, just so you are now on notice. I'd like to thank the Dean's Office for sponsoring our lunches, our talks and our lunches, and then particularly today our co-sponsors, the Harvard International Law Journal. So thank you for supporting our book talks. So it's my pleasure to introduce Anthea Roberts, who is our author. She's an associate professor in the School of Regulation and Global Governance at the Australian National University. She visited here, so that's part of her connection with us. She writes and teaches in the area of international and comparative law. Among many accomplishments, Professor Roberts serves on the editorial board of the American Journal of International Law, which is one of the preeminent journals on international law. And as a librarian, I read that. She's also a reporter for the Restatement Fourth of the Foreign Relations Law of the United States. She's joined today by two of Harvard Law's professors, Professor Naz Modrazadeh. I just said it wrong. I was practicing. Okay, good. And Professor Mark Wu. Professor Modrazadeh, I'm getting there, is the founding director of the Harvard Law School Program on International Law and Armed Conflict, and she researches and teaches in the area and the intersection of international human rights, international humanitarian law, and Islamic law. And Professor Wu is a faculty director at the Berkman Klein Center, and he researches and teaches in the areas of international trade, IP, emerging economies, and a bunch of other interesting international topics. So I will stop talking. I will turn it over to Professor Roberts, and we'll get started. Thanks. And you're all set. I think you just need to click.
Oh, I'm going. Fantastic. Yep. Okay. Well, thank you very much for that warm introduction and also for having me here. This is actually a book in many ways that was started here at Harvard Law School, and that's because I'm originally an Australian-trained international lawyer. I studied in Australia, the UK, and the US, and then I started working and teaching as an international lawyer in the US, then the UK, then Australia, and then came back here to teach. And it was really when I came back here to teach that I started to become very aware that there were very different communities of international lawyers between these three different states. And that made me start to wonder about this idea which I started calling comparative international law. Because I became aware that we are quite used to the idea of comparative domestic law because we expect Indian law to be different to German law in a way that it might be interesting to study the similarities and the differences. But when it comes to international law, we didn't really have much of a language of comparative international law because, by its definition, international law likes to assume and assert universality. And it was really by moving around and studying and teaching and working in three different countries that I began to question this universality and become much more aware of the different communities of international lawyers. And also much more aware that this was from moving between three extremely similar states, the US, the UK, Australia, Western English-speaking common law, which made me much more attentive to the question of, well, what does international law look like if I were to come from Russia or if I were to come from China? And that is really the origin of this book. When I started to think about the idea of comparative international law, I really started to orient myself around three different concepts that would come up repeatedly in my work. The first was the question of difference. Do we find different national or regional approaches to international law in a way that it's interesting to study and compare? The second was dominance. Are there certain national or regional approaches that have had a disproportionate role in being able to claim the space as being the neutral international? And finally, are we facing disruptions? Disruptions could be from technology or, in particular, what I focus on, changing geopolitics and economics, which mean that some of the established patterns we have of difference and dominance are going to be upended in this next generation. Now, the best analogy I have for the kind of work I've done here is actually an analogy from language, which is international law likes to think of itself as Esperanto. It likes to think of itself as this constructed language that happens between states that everybody has an equal buy-in to and is actually intended to foster world peace. It was actually also suggested as the language for the League of Nations. But in fact, what we actually end up with in this world is a combination of two things. Multilingualism, which is much like difference, where we have different communities of speakers of different languages, where there's much more interaction within the community than across communities, and we don't always know whether we're saying the same things in different communities or different things in different communities. That's on the one hand, that's difference. And on the other hand, dominance. We have certain languages, and here particularly English, which becomes the global lingua franca and is a case of one particular national or regional approach coming to dominate what is classed as the international. And the language tension really exists in this kind of push and pull between the multilingualism, the difference, and the English as the lingua franca, the dominance. Now, how was I going to study this? Well, I chose not to study the international law per se, but in fact the communities of international lawyers and their sociology that lead to the interaction with the international law per se. And I knew that I could not really study the government international lawyers because you simply cannot find the information about the backgrounds and the profiles of the government international lawyers. So instead I chose to study the academy because the academy is much more visible. You can find out much more information about the international lawyers. And the international lawyers also in the academy play a particularly strong role in the construction of international law, both because their work ends up being cited as evidence of international law, because there is a very strong connection between the international law academics and various forms of international law practice. The textbooks they use are considered to be some of the bread and butter understanding of international law and are cited to by international courts and tribunals. So I studied this particular group, recognizing that there are some limitations to how you can cross-apply that to government lawyers, for example. And I chose to study it with respect to the 5 permanent members of the Security Council, which was an interesting choice because they've all historically been privileged in international law. They're a nice mix of Western, non-Western, English-speaking, non-English-speaking, common law, civil law. So they're interesting in that respect. But of course, with any selection of states, you also have various blind spots. So with this, you don't see Latin America, you don't see Africa, and you also miss some of the core periphery dynamics. So this is by no means an exhaustive study, but it's one of the first forays, or I'd say it is the first foray to do this kind of work in a comparative international law vein, looking at the sociology of international lawyers in different countries. Now, I'm going to divide my talk into 3 today to talk about this idea of difference, about dominance, and about disruption. So I'm going to start with difference. And there are many aspects in the book that deal with difference. The one I want to highlight here is this idea of the invisible college of international lawyers, because international lawyers love this idea that we're all part of an invisible college, we're engaged in a continuous process of communication and exchange. But what I came to realize in my study was that actually we're more like the divisible college of international lawyers, where we have very distinct different groupings of international lawyers, some very national, others transnational but often very Western, and various combinations in between, where you see that through different things like the way in which you're educated, where you're educated, how you're socialized and incentivized by where you publish, actually creates very different communities with very different understandings of what the international law topics are and what the accepted parameters of debate are. And so one of the examples I'll give you of this is that when it came to Crimea, you ended up having a Russian international law debate, which was by the Russians, in the Russian language, in the Russian publications, that was a wholly and utterly different conversation to by the Western international lawyers in English, in the English language publications. And you could even see it down to their very first assumptions, whether it was Russia's annexation of Crimea or Crimea's reunification and self-determination with Russia. These were completely separate communities, and one of the really interesting things about it was not only that they were different, but there was almost no exchange between these communities at all. They were largely self-contained. Now, you might think, well, that's because it's China, that's because it's Russia and the US, right? They're both very different. But interestingly, you actually find very different communities of international lawyers, even between the US and UK, where I had been teaching. So in the US, you found, primarily speaking, at the top law schools, that most of the international lawyers had done 1 law degree in the United States. They then worked for a US district court judge, a US Supreme Court judge. Half of them went and worked for the US State Department. They then tried to come back and publish in Germany generalist US law journals to appeal to a generalist US law faculty. All of these things had a very strong nationalising effect, which meant that they largely focused on foreign relations law topic, international law and domestic courts. National security. A completely different picture emerges when you go to the UK, where about 75% of the international lawyers there not only got their law degrees from more than one state, but got their first law degree from outside the United Kingdom, which is a very good proxy for the fact that they're not British nationals. They did not study British public law. They did not work for the UK government. They did not work for UK courts. They, in no respects, do British foreign relations law. Instead, they focus very strongly on international courts and tribunals and have a completely different network and a completely different set of assumptions about what international law is and what our assumptions are, even though they're both English-speaking core Western states. So I end up finding these very different communities of international lawyers who have different focuses, approach different things, have different networks. But I also found that they had very different connections to practice. As I mentioned earlier, the US lawyers were particular for how strongly they were connected to the US government, and I think in ways that deeply shaped the scholarship in this country. The UK and the French international lawyers, not at all really connected with their government, but deeply connected with the international courts and tribunals and international adjudication in a way that I also think affects their approach to international law. And so we can see that these not just happen in the classroom and not just in the textbooks, but also very much in their connections to practice and who they influence and who they are influenced by. But it's not just connections to practice, it's also other incentives like funding. And so to give you a bit of an example of this, whereas the US government lawyers were very connected with the government, the UK and French ones, for example, if you look at who the professors are that appear before the International Court of Justice, you'll see it's strongly they all come from the West. But within the US, there's a massive duopoly of the UK and France, so you can see very strong capture of these international organisations by certain communities. But you go across to China and you see something very different, which is the Chinese government actually puts out recommended topics of research on international law each year. So I actually started to code what did they recommend international lawyers focus on and what did they fund. And what you see there is a very strong emphasis on international economic law, law of the sea, post the 2009, and international environmental law. And the kind of international lawyers that China is incentivizing and producing are not only completely different to what you have here in the United States, but there is a complete mismatch between the types of expertise that are being developed in the academies of these two states. So that gives you some small background about some of the different communities of international lawyers. What about what it is that we teach as international law? Well, I started to notice that what it was that we actually taught as international law was also quite different between these different states. And again, I first noticed that here at Harvard Law School when I went to teach a 1L class. And I thought, look, I'm used to teaching from a UK textbook back in the UK, but you know, the American students, it's all international, it'll be fine, but I'll set a US cases and materials book because they're used to that case-based method. And suddenly I was in front of 92 first years twice a week teaching US Supreme Court cases that I had never read before. And I was shocked because not only did I not think that the US Supreme Court was the authority on international law, when I read these cases that I hadn't read before, I actually thought the US Supreme Court was not a good student of international law either. But I thought, look, maybe this is me, maybe it looks domestic because I'm not used to it. So I actually started to look at all the textbooks, the main textbooks in the different states, to say, well, look, how inwardly focused or outwardly focused are they? And I started to say, you know, what percentage of the cases they refer to come from their own domestic courts, red, from international courts, blue, or from foreign courts, green. So it turns out I wasn't imagining it. The American casebooks were absolute outliers for having a huge and disproportionate emphasis on international law as interpreted by US courts. You flip across to China in contrast, and out of the 5 main textbooks I studied there was not a single domestic Chinese case, and we'll come to why in a second. And then you go across to France, and basically France, it's the ICJ and us, and nobody else matters in the world. And I have to say, that seemed like many of the French international lawyers I know. Now, this ended up actually, I thought, well, maybe it's just string citations, maybe it's not representative. But if you actually look at which cases are taught by the sort of frequency with which they're referenced in the book, what I started to see is that in some of the US books, you see a very, very strong preponderance of the cases by US Supreme Courts. And the one real exception here is Nicaragua in the US, where the US was taken to the ICJ, objected to jurisdiction. When the ICJ said we still have jurisdiction, the US said, I'm going to take my bat and ball and go home. And that's the main international law case you would learn from this particular textbook, which is one of the US textbooks. Compared to the UK textbooks, where almost all of the big cases are actually by international courts and tribunals. And the one main exception is, one main one in common is Nicaragua in the US, which sits at the intersection of the international and US foreign relations law. But when you learn Nicaragua in the US in this context, it looks like the US is the outlier. When you learn Nicaragua in the US in this context, it looks much more like international courts don't matter. And in terms of the idea that the UK lawyers are not UK foreign relations lawyers, you can see one case here, this one, Pinochet, is the one major domestic UK case. After that, you can see Jones, and after that, you actually can't really see any of the UK decisions, because it is fundamentally not considered to be a foreign relations law subject in the UK. But that's just generally how international or how domestic you are. One of the other questions I wanted to know is, how Western is this field? And so I wanted to look at, for example, all of the domestic cases that were cited, and I wanted to ask the question, well, where do they come from and how regionally representative are they? So here are the geopolitical groups from the UN, and the one I want you to pay particular attention to is the yellow. So how yellow are our textbooks? And I would have to say the answer is shockingly so. So when you look at all of the domestic cases, for France, that's 99.6% were Western cases. The US, 99%, great diversity from the UK with 96%. And one of the things I started to realise from this is people are then like, well, of course, that they're the ones that have the decisions. But then you actually have to realise that some of the metrics that you take for granted as a way to approach international law, like understanding it through case law of domestic courts, seems so natural when you come from the West in general and from common law in particular, actually render invisible really important countries like China that do a lot of international law, but not through their domestic courts. It's also the case that this West is not equal within the West, and often 70 or 80% of the cases were just to two Western states, the US and UK. So we have Western dominance in general and Anglo-American dominance in particular. And this is a feature that we see again and again of what is claimed to be the international. But it wasn't just the case citations, and it wasn't just these differences of emphasis. There were also substantive differences as well. So when I started the study, I was deeply amused to find that all of the Russian international law textbooks had an entire chapter on the law of outer space, which had never occurred to me to be relevant, and often had twice as much treatment on the law of outer space than they did on international trade law, which I had assumed to be quite relevant. Now, I'd assumed that that was just a throwback to the fact that they had been communist, not very connected with the international system, and the space thing was just because they put the first astronaut up into space. But when I actually read these books, read these materials, I realised that they were actually raising some really difficult questions about how technology has really increased, the ability to go into space has really increased, for commercial reasons and military reasons. It's being by non-state actors now, and yet the legal regulation has largely stalled. And it was something I was totally unaware about from my Western textbooks. On the other hand, in my Western textbooks, I had always learned about unilateral humanitarian intervention and, for example, Kosovo. And I had learned and taught that, well, Kosovo, it was illegal, but it was legitimate, and there was probably an emerging norm in favour of unilateral humanitarian intervention. But if I flipped across to the Russian books, I certainly didn't learn that it was illegal but legitimate. I learned about the NATO war criminals who had illegally used force in Yugoslavia. I learned about the utter illegitimacy of the ICTY that even caused Milosevic's death by withholding valuable, vital medical treatment from him. And I got a totally different impression. But I also got a totally different impression of not just what the issues were, but who the good guys and who the bad guys were. So in what I was used to teaching, it was the West that was pushing forward for human rights, and it was that naughty and recalcitrant Russia and China that were vetoing and stopping it. Whereas when I went across up into outer space, it was actually China and Russia that were pushing for new international treaties, and that militant the US that wasn't agreeing to international regulation or to demilitarization. So very different narratives. But it wasn't just differences between the West and the non-West here. It was also within the West, for example. So, for example, on the legality of war in Iraq, in many of my US materials, I found 20 or 30 pages of really detailed material that allowed you to really clearly follow the argument about the revival and the US materials and to try and understand the case. And it wasn't that at the end they said, this is lawful, but you were left with a very strong sense that this is arguable and this is open-ended. You go to the French international law textbooks, and in one page, sometimes two, they would very clearly state under a heading, illegal invasion of Iraq 2003, and there was no sense that this was open and arguable. It was that the US and UK tried to argue it, and it was wrong, full stop. Okay? So very different senses of what's an open issue, what's a closed issue, what the law is. But where does this leave us? Well, I think where it leaves us is having to think very, very carefully about what international law looks like in this next generation. And that's particularly because we're facing various geopolitical and economic disruptions. So when I said at the beginning that I had not been familiar with an idea of comparative international law, that simply betrays my age, because I was an international law baby that came of age in the post-Cold War period. And it turns out if I had just gone back one generation earlier to the Cold War, actually there was a really clear idea of Western approaches to international law and Soviet approaches because we had bipolar power. In the post-Cold War era, we have unipolar power and a much stronger sense of universal international law, square brackets, Western, Anglo-American, but let's not talk about that aspect. And that was the international law I knew. But now we're moving into what I call a competitive world order, and I have to say I called it that before the national security strategy, where we're moving into a multipolar era, where we're seeing a strong challenge to this Western order from countries like China and from countries like Russia. And I think this is going to make us think much more consciously about different approaches to international law and needing to understand them. So we can see these examples coming up all over the place in terms of current debates. One of them, for example, are Chinese and Russian versus Western approaches on cybersecurity, where you see a very different approach to whether or not the internet should be treated as a global commons, or whether or not that you should have the much stronger sovereignty conception, which you see in all of the approaches to international law from China and Russia, which would seek to balkanize the internet. And they actually use the idea of cyber sovereignty and cyber territory in just the same way as they push the idea that state sovereignty is still the supreme in international law and should not be watered down. You also see it in the format of those debates about who should be at the table. It turns out the hottest topic in the Russian International Law Academy is whether or not only states are subjects of international law or whether individuals are too. And the reason that's such a hot topic, even though it had never occurred to me as a hot topic in the West, is that that has become a proxy debate in the Russian Academy for those that are more Soviet-inspired, who hark back to the state sovereignty, and those that are more Western-inspired, who want to break it down in favour of the individual. And it also maps onto the debates that are happening about cybersecurity, where China and Russia are saying, no, it has to be an interstate treaty between states, whereas the West is saying, global governance, we should have corporations at the table, very different approaches on this issue. We also see very different approaches between, for example, some of the Chinese scholars and some of the Western scholars on the South China Sea. We not just see very different narratives in the papers and in the scholarly treatment on things like the West focusing very strongly on the fact that China didn't turn up to the tribunal, that it was ignoring the decision and that it was being aggressive in the region, versus what you saw very strongly in the Chinese materials, which was that China had gone through a century of humiliation at the hands of the West. It had never been aggressive, and here it had a very strong and legitimate jurisdictional objection, which meant that it shouldn't be taken before this court. So you had very, very different narratives, but unlike in the Crimea example, where these two communities didn't connect, the Chinese international lawyers typically, particularly in the younger generation, do their first law degree in China, their second and third law degree in the West, because they're incentivized to. They learn to speak English, they're incentivized to publish in English language journals, and so they are actually able to cross out of this silo in a way that the Russians aren't. But it's asymmetrical. We're not learning Chinese, we're not incentivized to publish in their journals, and even if we wanted to, there would be issues about censorship. And so we're seeing some engagement, but we're seeing asymmetries in this engagement. So at the end of the day, when I ask myself, is international law international, what I see are very clear patterns of difference with the communities and what they focus on and how they approach international law. I see very clear patterns of Western dominance in general and Anglo-American dominance in particular. But I see a situation where a lot of this is going to be disrupted in the next order. And what that says to me is that we really need to make ourselves much more conscious of our own blinders and try to see international law through the eyes of others. We need to diversify our perspectives. We need to diversify the sources of materials we use. We need to diversify our networks so we have a better understanding of approaches from different states. And by that I mean you don't have to agree with everything you read that comes from a different community, but you need to understand the way in which they're viewing you and the way in which they have understood and approached international law. And you also need to use that to check your own blind spots. One of the things that I found really interesting about this approach was not that I agreed with everything I read in the Chinese and Russian approaches, I certainly did not, but they helped identify for me some of the gaps and blind spots and biases in my own materials that I was not aware of. And they say in psychology, often we're much better at updating our understanding of the other based on new material than our own self-understanding. Well, I tell you what, often in these materials, the Chinese often gave a much better and accurate understanding of the US, but not of themselves. And the US materials often gave a much better accurate understanding of China, but not of themselves. And so I want to encourage us to be more open-minded about this. This does present a real challenge for what international law is in the next generation, but this is a challenge that we have to face. And so with that, I open it up to comments and questions. Thank you.
Well, Anthea, I want to first start by just welcoming you back to Harvard. I know this project began 5 years ago when you were here, and there were several exciting conversations that we had and others had on this faculty that spawned this wonderful book. I'm going to make 5 points here today, and the first point that I'm going to make is just simply to extol the virtues of this book. I think both Anthea as well as the library probably were almost too humble to note that this book is the recipient of the American Society of International Law's 2018 Book of the Year as far as the preeminent contribution for creative scholarship in international law. So if there's anything to sort of warrant you to say, if there's one book that the American international legal community thinks you should read this year, this is that book. So this leads me to my first point, which is it's interesting, that we as Americans, see merit to this book after it's produced. But one of the first points that I want to highlight is the point that Anthea makes in this book about the parochialism of U.S. international law, and what I will highlight as this American need to put everything into boxes. And so we teach you, how to categorize everything, and then within these we simplify it into there are certain veins that are attached. So in domestic law, textualism versus purposivism, in international law we talk about whether treaties are contracts versus constitutions, and so on and so forth, One of the things I think is most astonishing or is really a virtue of all this. In international law, the other divide that we have is this divide between what we think of as the orthodoxy and the critical legal studies third world approach to international law. And these are sort of two communities that almost talk past one another. And I know that when Anthea took on this project, there was pushback from a number of folks who I would say fall into that orthodoxy camp, who said, whoa, wait a minute, this is a very dangerous topic for somebody like you who doesn't identify as a crit or as a TOEL scholar to undertake, and this sort of need to sort of pigeonhole folks into this type of scholarship. But really what this book has done is confirmed what I think many of the critical legal scholars, the TOEL scholars, have always suspected, that the international law is not necessarily universalist. It reflects a certain type of mindset that's tied itself to the West. And particularly to an Anglo-American type of tradition. And we can debate whether that's good or bad and so on and so forth. But the first question that I just want to raise is, is there something about the American Legal Academy, where these types of projects are seen as risky rather than actually encouraged? And does it actually, should we as Americans look back to say, why is it that it takes somebody from the outside to immerse themselves here and to notice our own problems rather than we being aware of these types of parochialism within the U.S. Academy? And I know some people, particularly associated with critical legal studies, with TOEL and so forth, have made these types of arguments, but they have not worked their way into the orthodoxy. If anything, they continue to linger on the brinks of the heterodoxy now more than a generation later. And I think that's a real issue or challenge to our American tendency to put everything into boxes. The second point that I wanted to highlight is the question about what do we do about this? Well, I think, like with anything, awareness of the problem is a first step, right, to all this. And I think Anthea has made a great contribution that I hope will resonate within the U.S., that this is a problem. But I think, ironically, the U.S. domestic political debate has highlighted for many of us why this is a problem, right? Because just as the left is only speaking to the left and the right is only speaking to the right today, if we are to use international law as a tool by which to mitigate conflicts, whether these are economic, whether these are security related, whether they are in outer space or seas or any of the other global commons. And if we're to find ways to cooperate on all this, right, we need to find a common framework by which to do so. And there is a problem when these communities speak to one another, speak only to one another, and that they do so, or that one community demands that these be done on its own terms, right? This expectation that amongst, I think, some of us who are American, right? Well, the world comes to Harvard. And by having the world come to Harvard, and by having all of you engage in the discourse that we in the American Legal Academy, or we could say, right, in the Transatlantic Legal Academy engage on, that is our means of soliciting the input from the rest of the world. And I think there's a recognition that just because, right, folks from outside of that transatlantic tradition come here, study here, master these types of terms, and are able to engage with us in debate on our terms, does not necessarily mean that they buy into these types of norms. And that there needs to be much more of an effort made to venture outward, to have these debates be on neutral terms or on mutual terms. And one of the things I want to highlight is some of this is going to be forged by requiring you to immerse yourselves elsewhere, right? Whether that's immersing yourself in a legal academy outside of this type of tradition, whether it's by spending time, right, prior to law school or after law school, or by just attending conferences that are not in English, that are not dominated by transatlantic Western scholars, and so on and so forth. And I think technology, ironically, will make this a little bit easier, but it's incumbent upon us to forge the interpersonal ties to make that happen. And I don't know if I see anyone in this room who took part in a seminar that I had 2 years ago, but I think some of you will know 2 years ago we had the prescience to actually have a seminar on U.S.-China economic conflicts and highlighting how there was a large divide and how several of these problems were not necessarily easy to solve. And we did this in conjunction with Tsinghua Law School with another professor who had also been a trade negotiator in the Chinese government. And one of the terms that we set up, it took us 2 years of just meeting, coming to the terms and so forth, just to set up this type of course. But one of the things that we both agreed upon was that we would do so in a way that this would be student-led, that we wouldn't have, right, the traditions of just the professors preaching as to what this is, and to have a mutual type of engagement of dialogue, whereby the terms by which this discussion took place were not in English, right? Either participant could choose in either language that they wanted to, and there was simultaneous translation being provided for. And I think those types of, right, that made a huge difference, right, when either side could engage on its own terms. And in particular, it's very impressive, right, because several people in my seminar, right, would speak to their Chinese counterparts in Mandarin Chinese and vice versa. But it really changed just by having the language go back and forth between the two languages, really changed the nature of those types of understanding. And there's a WeChat group, right, and again, not set up on Facebook. Now, part of this is technology, right? You can't get onto Facebook, but this is all done on, there's a WeChat group that I understand has endured for coming out from the participants in these types of seminars. So in some ways, technology makes this a lot easier. But what I want to highlight from this is solving the problem still requires people to be aware of the problem and then to find ways to engage this on other types of terms, right? So the third thing then, I just demonstrated my guiltiness as an American trained, right? Of course, I begin with my two comments about America, right? But let me venture a little bit forth outside of this, right, and not make the U.S. the center of all of this. The third point that I think is very important to highlight about all this is the divide that's highlighted here in terms of within the West, and particularly within what I would highlight is a continental tradition as opposed to a Anglo-American tradition. One can think of this as a common law, civil law divide, but I think in many ways this is also informed by our own historical experiences and the way Europeans think about the role that EU law has played as international law and what that has done in terms of preserving the peace on the continent, and how that ventures forth in terms of what your views about international institutions are, as opposed to those who most closely value their sovereignty and are much more shall one say, skeptical about the types of encroachment or distrustful that international institutions can play upon regulating sovereign space. This is different than, I would say, a civil law, common law divide. This is different than necessarily, say, just a European-American type of divide. But I think this is a fault line that runs through international law, and it's a key fault line. I think this book does a fantastic job highlighting all of this. The fourth point that I want to highlight is, of course, one of the reactions people ask is, well, and they ask this quite often of me, particularly with regards to China, but I think it's a question that oftentimes gets asked, right? Well, where is China on this? Or where is India on this? Or what does this say about Africa, right? And one of the things that I wanted to highlight is I think that those questions in and of themselves reflect part of the problem about the way we see these types of issues. Because, right, these are continents with a huge amount of heterogeneity within them, with huge amounts of debates within those types of communities. And just as you would not say, where is America on cybersecurity, or where is America on trade, right? You make an effort to disaggregate where are the different constituent parts, and you understand how changing dynamics within that change the orthodoxy within each of these different clusters. I think there is much more work to be done on our part in terms of understanding all of this. And I would say, right, with regards to the China question in particular, this is still a work in progress to be determined, and we shouldn't expect necessarily, right, that this principle or this desire to put it into a box and say, here are the 3 bullet points about Chinese views about international law, or to expect that Nigeria or South Africa speaks for the entire African continent, right, to actually hold true in this type of context. Which leads me to my final point, and my final point is geared towards those of you in this audience who are especially come outside of the Western or Anglo-American type of tradition. I see many of you here in this audience. I know I supervise some of you, and I do say to you that when I supervise you, right, I do teach you to write in this type of American tradition and to engage with America on its own terms. I say that because I think it's important for all of you as international lawyers, right, to recognize the U.S. will remain a dominant power in this, and you need to be able to engage America on its terms. But I want to make a second command, which is to say, I hope this does not come at the expense of actually forcing you to adopt the type of voices that, right, it's to teach you to be more nimble as a lawyer in this type of space. But I hope it doesn't cause you to actually lose your own voice. If anything, right, it's incumbent upon you, especially for those of you, right, who didn't see your colors reflected in there, to speak and engage and to make that type of voice heard in this discourse of ideas, and to do so in a way that can engage and attach those of us who come from this type of Western tradition, right? And I think we need to meet you more than halfway on this, rather than just sit here in our ivy towers and expect the world to come, right, to the Harvards and Yales and Stanfords and Princetons, and just basically this is where the debate takes place in English on Westphalian terms, right, with Grotius and these other white men who come from, right, Western Europe in the 16th, 17th, 18th centuries and so forth. We need to go there, but you also, it's incumbent upon you to do that job about laying that path to make it easier for all of us to do that. And I hope you all will do so when you venture forth, regardless of what you all do as your careers in international law. So with that, Anthea, congratulations on a wonderful book, and thank you for coming here to speak about it.
Thank you for the comments.
Great. Thank you so much. I think it is a mark of Professor Wu's correctness that he said he had 5 points. I'm going to have 3 points, so we're already categorizing our own comments like American international lawyers, I suppose. I wanted to echo Professor Wu's comments. I think this book is tremendous, and just from a personal standpoint, and my guess is that you've gotten a lot of comments that are both, of course, on the scholarly level, but also people having very personal reactions to the book. And I certainly felt not only a sense of deep recognition with your arguments and with your inquiry, but also I think often a sense that I was recognizing my own anxieties in the book, that the feeling of how do you teach this topic, not only in this country, but in any country? How do you balance the ideas of sort of a rooted, located, contextual way of teaching and talking about international law with this universal that ultimately, particularly for first-year students, we do want to teach, right? And we do want to invite them to be in awe of that universal before they go about tearing it apart or getting critical or thinking that it isn't real. So I want to ask you 3 sets of questions. 1 about teaching and course materials. 2 about what explains this phenomenon. I know you said a little bit in your talk and a bit in the book about the historical context. I just wanted to ask a bit more about that. And then 3, your sense of the normative implications and where we go from here. So first, just a personal story that I think resonated very much with your account of teaching here and also in the book. I had the same dilemma when I went to teach public international law for 1Ls this year. What book do I use? And I looked at all of the available PIL case books published in the U.S. and by U.S. authors, and I found that I did not think I would be able to teach with them. They just had so much U.S. law that I don't know that I thought it is going to be a disaster if I actually try to teach through this material. And I also shared Professor Roberts' sense that not only did the U.S. Supreme Court appear through these books to be a paragon of international legal development that I didn't feel capable of teaching, but also I often thought that the United States Supreme Court was indeed, if I could put it a bit more sharply, wrong on international law in many of the things it was studying. So I am using a UK textbook, the Evans book that is discussed in Professor Roberts' book. And I have enjoyed the experience, but I also think it's been very challenging for my students. It is astonishingly different from a U.S. casebook. In fact, it is not a casebook. And to teach it in the 1L curriculum when my students are taking torts and contracts and crim law, and then they walk into my class and we don't necessarily have cases, we are not teaching through the case study method, don't tell anyone, and it does not necessarily lend itself to a Harvard Law School style of teaching. We are looking at analysis, we are looking often at just very doctrinal, descriptive writing, and we are trying to kind of draw out of that the arguments, but in some ways it's much, much harder work. We had one chapter that actually had subheadings and bullet points, and we all took a moment to just appreciate that we finally had an outline in one of our chapters. So I guess my question there is 2 that came to mind. One is, if you teach in this more international way, right? So you don't use the U.S. casebook and you teach a more international law is real and is international style. How do you avoid making it into a topic that is so exotic or irrelevant that many of the students will just think, well, this is clearly not related to anything I will ever do in my practice? Most of our students will ultimately become US-based lawyers and practitioners. So how do you avoid it not being a class that just sort of seems like a throwaway? And second, I really liked your analysis of the Iraq War, and we just did it in my 1L class. And I guess I was wondering when I was reading that, to what extent is the U.S. case law casebook approach to the Iraq War part of the case study way of teaching? Meaning, so we were really struggling with this in my class. In our materials, we went through the Security Council resolutions on the Iraq War, and we did treat it as arguable. We really took seriously the argument that the U.S. and the U.K. might have been right in their interpretation of the Security Council resolution. And at a certain point, I said, if we were in France, if we were in Belgium, we would simply say, illegal, move on. We would not be having this conversation. So how much is it the way that we learn to think like lawyers, and do we want to preserve some of that moving forward? Secondly, I wonder, my instinct, having not done the hard work you've done in terms of the analysis and the empirical work, is that it wasn't always this way in the US, that there was a generation of scholars, maybe 2 generations ago, at least for HLS, that had multiple languages, had studied abroad, really saw themselves, while on the faculty here, as being engaged in an international project. And I'm wondering how much of our current situation, particularly the obsession with national security law, is about 9/11. That international law just became more popular after 9/11. I was looking at the Harvard Law Record magazine article on 10 years ago when PIL was introduced to the 1L curriculum for the first time. And the article starts by saying, Guantanamo Bay is one of the hottest questions facing lawyers today. They should know international law in order to talk about that. So I'm wondering, how much is it that we are at war and that sort of brings international law to the fore? My third set of questions is about sort of where do we go from here and the normative punch of what you're bringing forward. So for the where do we go from here, I guess my question is, if you had unlimited resources, is this a massive translation project? And I mean translation across both ways. Is this about going to 25 countries and actually building up international law teaching in a way that in one generation we would be able to get these new approaches and new languages? What would we do if we not only took your book seriously, but actually put behind it the time and resources that we might in order to engender the kinds of conversations that you talk about? And second, your book made me think about a debate that's been raging in comparative political theory about the value of these kinds of understanding and cross-cultural or cross-societal discussions. And I wonder whether you think that if the kind of exchange that you talked about at the very end of your talk occurs, will it change international law? I mean, do you think that behind this is a real possibility that if we took seriously not just the periphery, but those who are not in the P5 and their views on international law, that we might be looking at a very different content of the law that we study? A real disruption, I suppose, is the contemporary term to the core norms and even the sources of law that we consider to be doctrinally binding. Or is it a diversity project? That really what we're going for is let's hear the other, let's understand these diverse perspectives, but ultimately the project remains this sort of as universal as we might think it is, problematically universal international law. But once again, thank you so much. I think this is a contribution that is going to stand the test of time and really, really challenges us to think differently about what we do.
Thank you. So an absolutely fabulous set of questions and engagement. I don't think I can address all of them, but let me do my best to address a number of them. So I think Professor Wu was right to start off with the question of how does this connect with critical legal studies and also third world approaches. And the interesting point about that is I think he's quite right that there have been these boxes, either of the third world approaches or the CLS approaches. And one of the things I noticed about those boxes was that I was quite deeply sympathetic to a lot of the arguments that came from these traditions, but that I noticed that people who weren't sympathetic to them, as soon as they could box them as saying, oh, that's CLS or oh, that's third world, they just shut down and stopped engaging with them. And for that reason, I actually very self-consciously did not position this book as a third world approaches to international law or as a critical legal studies book. I positioned it as someone in the West, an English-speaking, Anglophone international lawyer, someone within the orthodoxy speaking to the orthodoxy, saying, hey, guys, what are we doing here? And that was deliberately to try and make this community of which I was a part open to actually having this discussion in a way that I felt they often shut it down if they could say, you're an outsider, you're the other, and it doesn't count, and I discredit it. But there are politics behind that choice, and different people could make different choices about that with different implications. The second thing I wanted to pick up on was this idea of, well, you know, Harvard Law School, it represents the world because all the world comes to us. And I'm not endorsing that, and you weren't endorsing that as well. But one of the things I want to say about that is it was extremely stark to me when I came here, these different ideas of what is the international. And I had an incredibly international student body. And yet I would go and have the faculty lunches, and I would be almost entirely with Americans. And this disconnect between the largely American trained professors and this highly internationalized student body made me think a lot about the claim to the international. And it also made me think a lot about the transfer of knowledge. And so it became very clear, and I've got some slides on this, about what I started to see with the global flow of students and how this constructs fields, is that students flow often from periphery towards core, from non-Western towards Western, and from non-English speaking towards English speaking. But ideas and materials and sources tend to flow back out the other direction. And so it creates this really interesting situation where those who begin and start in the core in America are often the best able to diffuse their approaches, and yet they themselves are the most parochial because they have no incentive to go elsewhere. And so you have these asymmetries as students coming in, like many of you. You will take many of the ideas from your American professors here back out, and yet they take remarkably little of your ideas back in, because there is a hierarchical dynamic here where, frankly, you listen to us a lot more than we listen to you, and you need to get inside our heads because we set the exams rather than we have to get inside on your exam set. And these sort of dynamics really shape the construction of international fields well outside what we have in international law. It's a bigger problem. And so it really creates a problem when you have something like the rise of China, where the Chinese students are incentivized to come and understand the Western approaches, but the West is not incentivized to get inside the head and frankly knows incredibly little about the non-Western approaches. And this isn't just international law. If you look at like international relations, 90% of what the international relations scholars teach in this country and set for their syllabus, over 90% is just other international relations things by other American international relations scholars who only speak one language, right? Your ability to understand the world through this metric is severely limited. And so that's going to be a real problem that needs to be disrupted. The next point about there being a really interesting divide within the West, so I absolutely agree that there's a very interesting divide between like the European approach to international law and the American approach to international law. The Europeans would say there is the approach to international law, and the Americans are violators of international law. But you can also see it coming up really clearly in debates, for example, about investor-state arbitration at the moment. There's been a real legitimacy crisis with investor-state arbitration. So how do you deal with a legitimacy crisis? So the Europeans say, well, I know what we should do. We should internationalize and have a court. Sounds great. The same sort of thing we had in Europe, but let's make it for the world. And the Americans like, are you crazy? Legitimacy crisis? Let's get away from those international courts. Let's bring back sovereignty. And so these splits actually play out in real time in some of the debates we're seeing now. I very much echo the desire that you need to understand the global lingua franca and be able to play that game, but you need to use that voice without losing your voice. And so one of the really important things is to try and take some of the language and some of the tools that we have, but make sure you're identifying concerns from your country, from your region, from your perspective. And one of the things that happens when you come and study in the core, but also if you then try and publish in journals in the core, is that you're trying to do it on the priorities of the core, and that is, we need to be getting away from that. And you see this in economics all the time, where people go back to where they come from, and they're not incentivized to write about where they come from, Peru, for example, because you couldn't publish it in the US and UK, and they're taught to take some of the concerns about technology diffusion, for example, back to their countries, where these are not the pressing issues. So we need to find ways where we speak in a common language, but we don't have the intellectual agenda always set by the core. But whereas I was reacting very strongly when I first came here to the fact that I found international law was too national, one of the other things I found was that international law is not always national enough. And this goes to one of the other points that Professor Wu made, and I wanted to give a real contrast here, that when people sort of say, well, what's the approach in China and what's the approach in India? Not only is there great diversity, but interestingly, when you actually go to their materials, you often learn very little about their approach. And India is a very good example of this, where there are no Indian international law textbooks. They teach only from UK international law textbooks, and one of the realities of that is that they learn almost nothing about India's approach to international law. Even though India has a very active and interesting Supreme Court, it has very distinct approaches to international law from the United Kingdom. But if you learn from an international law textbook, it's not that international law is your domestic law. International law is something that is totally and utterly unrelated, and you are simply an importer and not an exporter at all. And this also goes to one of the other points that was made, like how do you make it connected? So I think I don't idealize that it should all be the international. I think there needs to be some healthy balance between what's happening at the international level, what's happening in its reception to your own country, and what's happening in the reception in other countries, the foreign dimension. And that's why I think of it as a sort of a comparative international law triangle of the international, the domestic, and the foreign, that it's that triangulation that gives us a better understanding of what it is we and others are doing and what constitutes the international law. So to some of the points about teaching. So yes, I was very struck by the difference between the case-based approach and the textbook approach. And there is really something about being taught to be a lawyer, and that's part of making arguments. But here's what I would say to that. I don't object to the idea that you should be taught to be a lawyer and to make the argument, but I object when the materials that you are given don't really allow you to make that proper argument. And the reason I would say that is when you look at a lot of the materials on the Iraq War in the US casebooks, is they set out the Security Council resolutions, they often set out what the US argument is, they set out some of the positions of US scholars, and then they say, and so what is the international law? And this happens quite often in these textbooks where they set out the American restatement, they set out what the US Supreme Court says, they set out what's written in some American journals, and they say, what is international law? And I say, I wouldn't know because you haven't given me the materials to effectively do that. So if you're going to be setting out the position of the US government, I also want you to be setting out the position of the French, the Russian, and the Chinese governments who had a very different interpretation of that resolution, and some of their scholars about. So, and at the end of the day, then you can make the arguments and you can come to your decision. But if you're going to make the case-based argument, you need to be aware of the diversity of your sources. Now, I completely agree that what we are seeing in this particular moment in time is not the case that has always been the case. And in addition to wanting to do a more of a horizontal study where you look at states, more states, you also would want to do a deeper dive domestically within these states and a deeper dive over history. And it is very much the case that you go back a generation ago, the US international lawyers often came over here because of World War II. They spoke multiple languages. They were very geared to the international. They were very geared to things like human rights and wanting to protect that. You then have that generation largely retiring or dying. The new generation that comes up often has a very strong foreign relations law focus. They've usually only studied international law in the US. They only speak English. And they do a completely different type of international law. Then you have 9/11 and the foreign relations law becomes much more national security law. You also have the international law, the interdisciplinary movement, which is often international law and many of the people are much better at the and than they are at the international part. And so you see this movement of segments over time, and various forces cause this. But it means that we can never just take a snapshot. We always have to understand how it moves over time. And then finally, what do you do with this? So does this really disrupt, if you took it seriously, does it disrupt the content of international law, or is it just a diversity point? It absolutely disrupts the content of international law. If you take seriously the views of the third world states, or you take seriously the views of China and Russia, we get a very different international law. First of all, we get a lot less agreement on what is international law. It's going to be a much narrower range. We're going to find it much harder to find agreement on new areas of international law. But also, interestingly, we have to take into consideration these views because geopolitical power is changing. But our views in the West also change when geopolitics changes. So you think about something like extraterritorial jurisdiction. You can be very in favour in the West of an expansive approach when you think you're the one expanding your jurisdiction. Suddenly, if you think you might be the one that is receiving the expansion, you have a tendency to moderate, right? And so as we see geopolitical power change, and we see this in investment treaties, we see this in a large range of areas, it's not just that the approaches of other states are different and that changes international law, but the changing power dynamic changes these Western approaches to international law, and that also changes approaches to international law going forward. We have very little time for questions, but I can open up to the floor. Oh, sorry.
Thank you, Professor Roberts. I got this book last September, so I've been reading it for the past 2 semesters. So I come from China, and it really echoed my experience. So one of the questions is, the underpinning of this book, according to, as I see it, is as you start from your first chapter, it's called The Divided College of International Lawyers. So it's echoing the Oscar Schackert's Invisible College of International Lawyers, so, which has both descriptive and prescriptive meaning in that. So when you mentioned the divided College of International Lawyers, what's your percentage of descriptive and prescriptive elements. Do you think that this divide, of course, it's factually true, but do you think that should be, like, for the future, something that we should aspire for? I mean, I think, at least till this moment, the invisible college still has a very compelling sense, even for people like me from the peripheries.
Yeah. So I think so the essence of that is that maybe the divisible college is descriptively accurate, but the invisible college is prescriptively where we want to go. Right? So I don't actually take a strong normative view on this. I do think the divisible college is what we've got. I think that I would like to see a lot more interconnection going on. So I'd like to see much stronger bonds going on between different communities. And one of my projects, and very much what you see at the end of this, is the desire to increase these networks. But I also think we also need to be deeply aware of the need to have our bonds both at the invisible college level between states, but also within states. And I think very much what you've seen in the US reaction at the moment is that if some of your international lawyers become too international, they can lose that connection domestically. And if they become too domestic, they can lose that connection internationally. So I think we need to be aware of the invisible college domestically and internationally, and that these are in tension with each other. Do we have time for...
Hi, thank you so much again. This was a world-changing presentation. I'm just curious, have you ever considered, those of you that taught PIL, to teach PIL through the US case law books, through Supreme Court cases, but with a supplement explaining how they're wrong, why they're wrong, and the perspectives of different countries, and whether that would be a solution or not?
I pass to you on that.
Yeah, I've heard of this idea. So I think there are some faculty who will use the regular case books and then use as supplements sort of either critical views or views that might take a different perspective. But I think in some ways the problem is that it already puts you in the language of U.S. law, right? So if you're looking at a U.S. Supreme Court case that is itself largely actually about domestic law, trying to keep it on the track of international law, I think is quite challenging. But that sounds like a good case book where you would have the Supreme Court case and then sort of challenges to the perspective within the book itself.
And I should also say, one of the other experiences that first led me to this was the very first case I ever worked on, working in international law at a US firm, was the Sosa and Alvarez Machine case, which ends up being one of the most cited cases here. And I was put on that case as a young foreign associate because I had written on customary international law, and there was this idea that the ATS was customary international law in US courts, so I was like, great, no problem. But of course, I had never studied an ATS case, which would be unheard of for an American international lawyer at that stage. But I was not fazed because it's all international. And so I went away over a weekend and read all of these ATS cases, and I was just completely and utterly horrified because it felt like they were using all this language I was used to, like state practice and opinio juris, but then finding it all by reference to US domestic court cases and doing really weird, like mixing an amalgamation of US corporate law principles with international law. And they didn't even seem to be asking the very first question, which is, do you have jurisdiction to do this at all? And they were asking the question, do we have jurisdiction under US law? I'm like, well, wait. Do you have jurisdiction under international law? Didn't seem to have been noticed at that point. And it has been noticed now. And so there's a really interesting divide then when you start to use these materials, how much do you buy into it and how much do you kind of react against it? It's really hard to have both discourses going, and I think we find that quite commonly. If you then want to litigate in the US court stuff, you kind of have to accept these cases as your baseline. You can't be forever being like, oh, and you made the decision wrong in the first place, and now it's still wrong, and it's still wrong, and it's still wrong. You sort of have to go, well, you made it incorrectly, but now that's the law, and I need to work within that. And so it's sort of, and so you can kind of disrupt it in various ways, but it gets very hard to hold these communities together. So you can make people aware of it, but they're very, very different dialects.
I'll just add, I don't teach PIL, but I think the one casebook I am a part of is not a casebook, right? It reads like a UK, European-style book, and that was a conscious choice that we did as co-authors because we felt like that's the right way to teach the subject materials. I think the answer, though, is we are at American law school, so it is important for you to understand how international law gets integrated into U.S. domestic law as part of that deep dive down this way. And so for those of you who've taken my 1L class, right, there is a portion we do that, but I think we need to do it in a way that's honest to say, look, the U.S. is actually an outlier, rather this is the norm by which this is how it's done in all the rest of the world, or the rest of the world is going to come to adopt this and highlight just exactly how the U.S. is an outlier.
And just to go on that last point, I think sometimes when I would sort of say to some of my US colleagues, well, it's done differently elsewhere, and they'll be like, oh, and then they'll be like, well, but, they're just a generation behind. So kind of like, well, we don't really need to know because it's just less good and they'll catch up to us. And I just think the world is changing. I think we need to know a bit more about what's going on and not just assume it's all going to be on the American dollar terms.
Any more questions? We're after 1 o'clock, but one more. Okay, if there are no more questions, then thanks again on behalf of the library for attending today's book talk. And I presume Professor Roberts will be here for a few minutes to sign books? All right, thanks again.